right now, I think of all the cases that have come before the International Court of Justice dealing with the Genocide Convention, there are now 19 of them. South Africa's case is the strongest.
But as a genocide scholar, would you say there is a genocide now taking place in Gaza? Given the evidence that you see, the multiple reports by human rights groups, including Amnesty International, that concluded that genocide is taking place. Human Rights Watch concluded that some certain acts of genocide have taken place. So what's your own conclusion?
That's my opinion. That's my opinion. Absolutely. Today, by failing to arrest him, they're violating the statute of the International Criminal Court. And hopefully there'll be some consequence. I feel sorry for poor old Karim that he cannot take his holidays in Disney World this year. And I also, if he still has an American bank account and he hasn't closed it, then I feel sorry for him by leaving himself exposed that way. And the only question really between Israel and the United States is, which is the dog and which is the tail that's being wagged by the dog. And our problem also, particularly with the situation in the Middle East, is that our mechanisms for the enforcement of international law, the political mechanisms, they are not designed to deal with something where the United States is the main culprit.
Welcome to this episode of Expert Witness. Today I'm joined by Professor William Schabas, a leading international criminal law professor and one of the world's leading scholars of genocide and international criminal law. We will delve into his personal journey and also hear his insights into events in the Middle East from a legal perspective. Thank you for joining us today, Professor Schabas. It's an honor to have you.
Thank you for having me.
You're welcome. First, let's talk about your personal journey. How did you become interested in international law? Talk about your childhood, your Jewish roots, and how that influenced your later interest in human rights law and international criminal law.
Well, I grew up in Canada. I was influenced then. You've mentioned my Jewish ancestry. Very much aware then of the Holocaust, of the Shoah. An understanding. I had relatives who were, of course, I didn't know them. I had those who had fled from Germany in the 1930s. They went to South America. But I knew about all of this. I knew that my family certainly had been touched by it. And I was very influenced by now we're talking the 1960s, by that history of the Jewish people. I was also influenced by other developments, by the Vietnam War. I had a grandmother who was very, very engaged in social causes. And I remember vividly I was probably 8 or 9 years old at the time. She was closely following the decolonization of African countries. And I remember her showing me a kind of a scrapbook that she kept of newspaper clippings. She had a map of Africa showing all the states as they became independent. So this must have been around 1958, 1960. And I started doing that as well. Following that, I followed the developments in apartheid South Africa. These were all things that influenced me and gave me a great interest in international affairs and human rights, although I had never imagined that I would work in that field. This is something that became much later in my life. I'd also, because I know we're going to talk a little bit about the Middle East and about Palestine. I don't recall in my family any great enthusiasm for Zionism in Israel. I think there's a sense out there that all Jews and all people of Jewish ancestry are somehow very committed to Israel. And I don't think that is the case. The majority of Jews in the world don't live in Israel. And many of them, there are many who have lived in Israel, who've left Israel to live elsewhere. And there are a lot of Jews, and I'm in that category, who really feel safest and most comfortable living with other people, living in a pluralist democracy where their identity is respected and where their rights are respected. But the idea that they want to live entirely among people, like them in a way, doesn't, it's never appealed to me. And I've lived now in several different countries. So I grew up in Canada. I lived in both English Canada and French Canada. They're all part of one country, but they're two separate peoples in many respects. And I developed close ties and friendships in both parts of Canada. I lived in Ireland for about 11 years. And now I divide my time between England and France. And that's, so I'm a bit, itinerant that way and very comfortable with that.
Professor Schabas, could you give us an insight into how you first became interested in international law and your journey, your career as an international law scholar or an academic lawyer?
Yes, well, that part of my career came relatively late in life, actually. I um, studied history at university and got a master's degree in history. Then I worked as a journalist for a number of years doing what we call trade journalism. I worked for industrial magazines. That was how I earned a living. And then when I was about 30, I went to law school. I qualified as a lawyer in Canada. And then I practiced law in a community where I was not doing international law. I was doing family law and small business law and small time criminals that was my work. And I continued studying, and I got a PhD in international law. And that kind of opened up that career. I was just about 40 years old. I just turned 40, and I got a teaching position at a university. And I started at about the same time being approached to participate in international human rights missions. I went on one of the early missions to Rwanda at the beginning of 1993, 15 months before the terrible genocide in 1994. And this was when I first developed my interest in genocide. We studied the conflict in Rwanda in 1993. I was part of a group of 10 people from different parts of the world who were investigating human rights. And we considered then and used the term genocide to describe what we saw or what we thought was being threatened in Rwanda. And I've been kind of close to that issue ever since. The encounter with genocide in Rwanda, first in the preliminaries as it was brewing in 1993, but then seeing it and then returning to Rwanda on many occasions for various projects and missions after the genocide in 1994, I developed this interest in this specialized area of international law known as genocide. But I'm interested in the broader issues. I'm very interested in going beyond genocide to what we call international criminal law, and beyond that to international human rights law, international humanitarian law, and more generally public international law. So I fit within those, Russian dolls of international law.
Mm-hmm. And can you talk a bit more about your Rwanda experience and what sort of analogy you could make between that and the situation in Gaza right now?
When I visited Rwanda for the first time, and as I say, this was 15 months before full-blown genocide began. That was April of 1994. So I was there in January of 93. And our use of the term, and I had just finished my PhD in international law. The people on the mission I was with were activists. There was a forensic pathologist. They were people, with different areas of expertise. People turned to me as the international lawyer. And they said, "You're the guy with the PhD. in international law. So tell us about the law of genocide. I must confess that I was not an expert at all. In those days, we treated the Genocide Convention and the subject as a kind of was something of historic interest rather than a real life concern at the time. It had been largely neglected by international legal scholars. And when we used the term in 1993, as I say, the members of the commission turned to me and said, well, can we use it? And I read the definition in the convention of 1948 and said, well, I think maybe it fits. And so we used the term, but then we were called up on it by others later who said, did we really know what we were talking about? And I remember going to the law libraries in Montreal. There were 3 university law faculties. I went to each one, had a law library, and went looking for the books on genocide, only to discover that legal scholars had not really studied the issue since the 1950s, or very little. And so I developed then a research project to learn more about the history of genocide and so on. We've often thought about why did we use this term in 1993? What was it about what was going on in Rwanda that made us use the term? And I don't think it was, I think in a strange way it was actually well informed. And as history showed, very sadly, we were right. What was more of an intuition than anything, rather than a profound legal analysis, was actually correct. We sensed that genocide was happening. And I believe that what determined that was we saw various acts of killing, of massacre, and so on, directed against the Tutsi minority in Rwanda. But that would not be enough to qualify as genocide. But they appeared to have the blessing of the government, of people high up in the government who had made not just racist statements directed against the Tutsi, but statements that suggested that they wanted to destroy them as a group, that they were going to destroy them somehow. And there was a famous speech at the time by someone who was very close to the president of the country saying, next time we drive them out, we're not going to drive them into another country, we're going to drive them into the river. There was this idea that they were going to destroy them. Since then, that was more than 30 years ago. Since then, I've seen many allegations of genocide, many cases where the term has been used. And often, I think it has been used in an extravagant way. It's been used as a kind of a super human rights violation notion rather than in a strictly legal sense, is looking at the intent to destroy a group identified by nationality, race, ethnicity, religion. When we see what's been happening in Gaza since October of 2023, we see these terrible acts of destruction directed against the Palestinian people, but accompanied by frequent, regular statements by people at the highest levels in the government of Israel that suggest that we're going to take over the territory and you'll be gone. And where will they go? We don't know, except that they'll be gone. Threats like the ones that Yoav Gallant made back in October of 2023, when he was then the Minister of Defense, saying, we're going to cut off all potable water, electricity, food, medical care, and so on. These types of statements, of which there are many, and which, are quite exceptional. We have many conflicts that are labeled genocide, some where there are strong elements of evidence. But when we look, for example, at the wars in the Balkans, in the former Yugoslavia in the 1990s, or more recently, statements in Darfur, in Sudan, or in Syria directed against the Yazidi, or in Myanmar directed against the Rohingya, there's nothing comparable to what we've seen, I don't think, in terms of the volume of the statements from the Israeli leaders, and the fact that they're coming from people at the top and not from sort of more isolated sources like a religious fanatic or simply a racist combatant who's doing tweets that are racist. This is so, to me, all of that contributes to the analysis, just as it did in 1993 when we of course, then in 1993, we saw the preparations for genocide. We anticipated them. And then 15 months later, we saw what has been, I think, universally recognized now as the greatest genocide since the genocides of the first half of the 20th century, of the European Jews, of the Armenians in 1915, and of the Nama and the Herero in Namibia, Southwest Africa, as it was then called, in the first decade of the 20th century.
And given these like strong pieces of evidence, do you think South Africa has a strong legal case now before the International Court of Justice? What's your anticipation or prediction with regards to this case? I know it's hard to predict the future, but given your legal expertise, do you think the evidence that we have and the ongoing massacres that are taking place in Gaza, do you think this case will eventually lead to basically the court deciding that Israel has violated the Genocide Convention?
There are probably three important variables that may change over time. This case filed by South Africa at the end of December of 2023 is unlikely to be heard in the oral hearing on the merits for, until probably 2028, something like this. 4 or 5 years is a normal time span for a case like this at the International Court of Justice. And what are the three variables? The first one is the evidence itself. So I have not seen the evidence because it's not public. It's not accessible to the public. This is the way the International Court of Justice works. The submissions of the evidence, of course, it's known to the parties. So the lawyers for South Africa, they, of course, know what was submitted. They've already made their main submissions. They did this a year ago, or nearly a year ago. As for Israel, their lawyers also know what it is, but neither side is going to talk about this publicly because the court would be very angry if it were to happen. And so we don't know what the evidence is that South Africa submitted. We know what's in the public domain. And that evidence, in my view, is quite strong and quite compelling. We don't know what Israel has in reply. And they may have, there are parts of Israel's conduct to which they could have an answer, and we need to hear them when they're charged with destroying a hospital. Did they have serious, credible evidence that throughout the hospital posed such a risk that it would warrant the destruction of the hospital? Well, we'll hear what they have to say. They'll have to do more than just say, yes, we knew there was a tunnel. They'll have to have, I think, very credible, serious evidence if they have it. And the destruction is on such a scale that, really we wonder what kind of evidence they even have, or whether they've even bothered to try and even gather such evidence. I chaired the fact-finding mission of the Human Rights Council in 2014. And there, when the Israeli Defense Forces attacked a building in Gaza with a tank or with a cannon or with a bomb from an airplane, they would answer it saying, we warned them, the people in the building. We could interview the people in the building who would say, we got a warning, but we didn't have enough time to get out of the building or something. There were debates about it. I don't think we have this. For most of the destruction in Gaza, I think Israel's just it looks to be completely, not random, it's one of total destruction. We see the pictures, of course, from Gaza, which are like, there's nothing comparable in the previous conflict. So this is the material evidence that will be very, very significant before the court, and also something that may evolve, because now we're into talking now in early 2025. We have a new round of attacks, displacement, and so on. And who knows what's going to happen in the next 2 or 3 years in Gaza and elsewhere in the West Bank and in East Jerusalem as well.
But they do have sometimes claims and arguments that the targets of their attacks are actually combatants and that civilians are collateral damage. And they also reject the fact that it's a genocide using international humanitarian law,
Yes.
arguments of proportionality in attacks, and claiming that, using the argument of self-defense, that Israel has a right to self-defense. So what's your legal counter-argument to that?
Well, as I say, the factual evidence, I cannot comment entirely on it because I haven't seen it all, and we haven't heard Israel's answer. So we'll see what they have. Of course, it's going to have to reach a level of credibility. They're going to have documents and evidence that demonstrate that that they have to answer it. That's the point. And they have to do it in a more serious way than simply saying, this is self-defense, we can do anything, which has been largely what I think we get from them at this point. So the second thing that can change here in this, or the second factor that's important, is the legal understanding of the crime of genocide. Until the present, we've had two big judgments of the International Court of Justice on the Genocide Convention, both of them in cases directed against Serbia, one by Bosnia, filed by Bosnia, and one by Croatia, dealing with the wars in the 1990s, and both of which were unsuccessful, essentially, where the court adopted an interpretation of the crime of genocide and they said, you just don't reach that level, the evidence. This is ethnic cleansing. These are war crimes, what were committed, but they don't reach the level of genocide. That may be changing. I think there's evidence to suggest that there's an evolution in the understanding of genocide. One of the things that we have with not just this case by South Africa, but there are several other genocide cases now. There are 4 other cases at the International Court of Justice dealing with genocide. One of them dealing with the conflict in Gaza as well. This is the one by Nicaragua against Germany. And there are a lot of states that have intervened in these cases. Again, this is something that has never, ever happened before at the International Court of Justice. So there are about 45 states that have intervened saying, here's what we think the definition of genocide is. And there's a lot of impetus there for the court to develop a more flexible approach to its understanding of genocide. Whether it will do that or not remains to be seen. We're going to have some insight into whether that's happening in the case filed by Gambia against Myanmar, dealing with the Rohingya, because that's likely to come to an oral hearing and a judgment. It's going to happen sooner than the South African case. In the next 2 years, say, we'll have that. And that will be the first time we'll be able to say whether or not the judges have developed a more liberal, generous, flexible approach to genocide. I think that even based on their rather strict and conservative approach in the 2 cases dealing with Serbia, I think South Africa still has a strong case. But if the court grants the application by Gambia against Myanmar, then South Africa will be it will be South Africa's case to lose. South Africa will have a very, very good chance. And then the final thing that can change at the International Court of Justice is the composition of the court. There are 15 judges, and every 3 years we have elections, and 5 judges rotate. And what we have today is a very unified court, as we've seen in various recent rulings, not just the rulings on the provisional measures that were requested by South Africa, but even more in a way in the advisory opinion on Israel's occupation of Palestine, which was issued in July of 2024. So we have a court that's very, very, that is quite unified, and that is quite, I would say, progressive in terms of its composition. The judges are dynamic, and maybe they're in a way reacting to this phenomenal interest from other states in the court. They want to react to that and respond to it by delivering the merchandise, by making it evident to so many states that the International Court of Justice is a useful institution where they can go to have important issues about human rights litigated and decided. And so that's something that also could change. These are all variables. If you were a betting shop in London and you asked me to say, what are the odds on South Africa, I would have to factor in all those elements in giving you a percentage of their chance of success. But right now, I think of all the cases that have come before the International Court of Justice dealing with the Genocide Convention, there are now 19 of them. South Africa's case is the strongest.
And the court has already issued 3 provisional measures orders, which are legally binding in theory, but of course, Israel has ignored most of the orders. So in your view, how important were these provisional measures orders, and what's the value of it if Israel has not abided by them?
The provisional measures orders issued by the court are important in not just in terms of the compliance by the state. And again, we'll wait to hear Israel's claim that they have abided by it or not. This has not yet been debated either. But in some cases, for example, they were told to take action about the hate speech that was a factor, and so they presumably will come and give some evidence that there were some investigations and so on. The court will decide how significant that is. And we can't know, I can't know how significant it might have been within Israel itself in terms of influencing the debate. This is hard to say. Outside Israel, I think that the provisional measures orders have had a significant impact on states that are friendly to Israel, but also loyal and supportive of the International Court of Justice. So we know that some European states that historically would have been pretty much on the same wavelength as the European Union in general have adopted positions now that strike one as being more critical of Israel and supportive of the Palestinian cause. Ireland, Norway, Spain, Belgium to some extent, Slovenia, I think. There are some, and there are debates within other countries as well. Some of that may have been influenced by the provisional measures orders. The provisional measures orders may also have influenced judges in domestic litigation when activists have gone to court, for example, to stop weapons, provision of weapons and war material to Israel. They may have been influential there.
So
and
they do have legal weight as well.
Well,
in other cases.
Not necessarily, but if you were a judge in the Netherlands and the lawyers came and said, you have to stop sending these weapons because you may be contributing to genocide, and the International Court of Justice has ruled by a strong majority that some of South Africa's claims based on the Genocide Convention are plausible. If you're a Dutch judge, you're going to say, well, I have to take that seriously. doesn't bind the judge necessarily, but it influences them. So I think there are a lot of influences that it's actually hard to quantify. And there's one other one that has been important for me in my own engagement in my own life and that of my academic colleagues at universities. We are encountering in the universities in Europe, in North America, maybe elsewhere in the world as well, attempts to muzzle freedom of speech, freedom of expression, and academic freedom in discussion about what's going on in the Middle East by the senior administrators, sometimes under pressure from the government. We've seen some of the stuff that's happened in the United States, but to some extent, this is going on as well in Europe, in the UK, and in France, where there's pressure on the universities from the state to ensure that they don't become platforms for statements, comments, and so on that are critical of Israel. And I can say from firsthand experience here at my university in London, back in 2023, when we proposed having a public session at the university dealing with it, at which I was to speak, I had words of caution from the dean saying, be very careful. There's a statement by the International Holocaust Remembrance Alliance about anti-Semitism. And I said to the dean, I'm of Jewish descent. I have ancestors who were Holocaust survivors. You don't have to lecture me about anti-Semitism. But it's enabled us to talk about it at the universities and elsewhere in the public. And this too is a good thing. And so all of these are results. But yes, it's true. The problem of the International Court of Justice is not with its ability to issue good, strong rulings that are backed by international legal arguments. It's that it's a court that doesn't have any enforcement powers. And that's just the nature of courts, really. Even in a domestic legal system, the courts issue judgments. They don't enforce the judgments. It's up to the other mechanisms to enforce them. And sometimes they do, and sometimes they don't, because they give immunity or something like this at the domestic level. So it's kind of the same problem at the international level. And our problem also, particularly with the situation in the Middle East, is that our mechanisms for the enforcement of international law, the political mechanisms, they are not designed to deal with something where the United States is the main culprit. That's all. The United Nations, people say, why doesn't the United Nations do anything? The United Nations was created by the United States in 1945. Its headquarters are in the United States. It was created to consolidate the American hegemony over the world. Of course, it's not designed to deal with violations by the United States. That's the problem. And as for other organizations like the European Union and the Council of Europe, why, although they're not beholden to the United States in a legal sense and they weren't controlled by it, they are Western institutions, and they're controlled also by people on the same wavelength as the United States. And this is why we're frustrated with the enforcement. But we're getting good law out of the International Court of Justice, and it's credible law because it's being issued by 15 judges who come from around the world. Judges from Africa, from the Middle East, from Asia, as well as from Europe. And the fact that they can all sign on to a statement gives a huge amount of credibility to their opinions and their rulings.
Mm-hmm. And Professor, you mentioned several cases against Serbia at the International Court of Justice. I know that not all of them concluded that there was a genocide, but in one of them in 2007, there was this landmark ruling that basically held that Serbia failed to prevent genocide. So, and you've used this argument in a case that you you were a counsel for in the US, basically arguing, making the legal argument that senior US officials, including former President Biden, Secretary of State Blinken, could potentially be held liable for violating the Genocide Convention based on the failure to prevent. Could you please talk about that?
Yes.
From
Yeah.
a legal perspective?
I was not a counsel in that case. I was an expert witness. I prepared an expert report for the court, for the lawyers who were making the application. I don't understand all of the technical parts about the application because they're trying to get US courts to declare that the president and the Secretary of State and the Secretary of Defense are violating international law. So this is a hard hill to climb, I think, anywhere in the world. And I think they've hit some legal obstacles that have nothing to do with the strength of their argument that those three personalities, starting with Biden, Blinken, and I forget the name. Austin, the Secretary of Defense at the time, that they were violating the Genocide Convention. But the legal argument is that, and it's derived from this judgment of the International Court of Justice in 2007 against Serbia. The Genocide Convention itself uses the word prevention. It's in the title. It's the Convention on the Prevention and Punishment of the Crime of Genocide. But pretty much 95% of the Genocide Convention is about punishment. It's about using criminal justice to prosecute individuals. That's what it was designed for. And the definition of genocide and so on was all created in that context. What the judges did in 2007 was they kind of created this new dimension of the convention, which, they drew it out of that word, prevention, which was very radical, because it said that there was this duty to intervene to prevent genocide, even when it's being committed by someone else outside your territory. And in the judgment of the court, they said, well, it's not so unusual. We have a few other treaties where this has been done, dealing with terrorism and torture, I think. But actually, when you read the treaties, they talk about preventing the crime on your territory, not outside your own territory. But the judges developed this thesis, and they said that the duty becomes a legal duty, not when genocide is committed, but when there's a serious risk of genocide. And proving that there's a serious risk of genocide in a court of law is obviously easier to do than proving that genocide has taken place. It's a different kind of proof, but it's not as demanding, obviously, because you don't have to prove that there's genocidal intent. You have to prove that there's a serious risk of it. And I think that I thought there was a very good case for this. So this is what's being litigated, by the way, in the case that Nicaragua filed against Germany. The idea of this obligation is that it's a variable obligation depending on the ability of the state to influence the other, those who are committing genocide, or where the risk arises. And in the case in Bosnia, by the way, it wasn't even a state. It was this entity of the Bosnian Serbs. And they said the Serb government in Serbia could influence them and failed to do so.
So that's even a lower bar than complicity, right?
Absolutely.
Yeah.
It's related to complicity. It's as if there's a kind of a spectrum, and the duty to prevent is more, at the red end of the spectrum, and complicity is at the blue end. To prove complicity, you have to prove the crime was committed, and that you gave assistance. You assisted in the commission. To prove that there's a failure of the duty to prevent, you have to prove that there's a serious risk, but you don't have to prove that it was committed. And you also don't have to prove that you provided assistance, but that you failed to use your influence to get them not to do it, which is not quite the same thing either. Although obviously, with a country like Germany that is providing material support to Israel, that if they were really trying to use their influence on Israel not to commit genocide, they would at the very least say, we're going to cut off the material support. Not just material support, but political support, diplomatic support, financial support, and so on. And all of that, they would have to show evidence that they took such measures to try and influence them, instead of what we suspect, which is the German chancellor talking to Netanyahu on the telephone saying, keep going, finish the job. We can't prove that either. If we had evidence of that, then we would have evidence of complicity. We do have lots of evidence of complicity in the case of the United States, if we can get them into court, not just for failure to prevent. And our best witness in that case is going to be Netanyahu himself, because he's the one who says, I went ahead and did this after I spoke to Trump. Trump gave me his blessing. Well, unless Trump denies that he gave him the blessing, I mean, Trump is capable of saying anything. But Netanyahu is saying, they encouraged us to do it. We told them what we were going to do, and they said, go ahead. Well, this is clear evidence of complicity. But as I say, to convict them for complicity, you will have to be able to prove that they were also, that genocide was being committed.
But is it the fact that the US continues to provide most arms to Israel, isn't that itself evidence of complicity?
Yes, of course. Absolutely. Absolutely. I don't think this is there's nothing mysterious about this part of it. And the only question really between Israel and the United States is, which is the dog and which is the tail that's being wagged by the dog, Many people, maybe some of the listeners, saw Jeff Sachs speaking before the European Parliament some weeks ago, and he says it's Israel who's calling the shots, and the United States is the tail that's being wagged by Israel, maybe, or maybe I don't know that Trump's the tail of anybody. I think he's the one who wags the tail, and Israel's the tail. But whatever it is, clearly these two entities, Israel and Israel, are joined at the hip, and that they're doing all of this with their in collaboration. It's very clear that it's a strong collaboration. That being said, maybe the United States is happy to have Israel as sort of its mad, uncontrolled pit bull dog that it uses in the Middle East, but clearly the two of them are joined in a way that we don't see the same way with the European powers, at least not to the same extent.
But as a genocide scholar, would you say there is a genocide now taking place in Gaza, given the evidence that you see, the multiple reports by human rights groups, including Amnesty International, that concluded that genocide is taking place? Human Rights Watch concluded that some certain acts of genocide have taken place. So what's your own conclusion?
That's my opinion. That's my opinion. Absolutely. And as I say, I've been following this for many, many years and studying many, many cases. I've never hesitated in certain situations, especially the historic ones, the Armenians, for example, and more recently, Rwanda. But this is clearly such a case of genocide. And there's nothing comparable in recent history, this idea of the borders are closed, the people have nowhere to go, and they're making life, have made life essentially impossible in Gaza. We see that combined with the ambition expressed sometimes very openly, both by Trump and by Netanyahu and the Israelis, to reconfigure Gaza as some sort of, Eastern Mediterranean Riviera with hotels and beaches and miniature golf courses and paragliding and stuff like that, which is what they dream of. But above all, it's this idea of expanding Israel's borders, both by eliminating Gaza as a Palestinian entity, but also the West Bank, because this resistance in Israel to the creation of a Palestinian state, despite the pledges, despite what was, amongst other things, in the Oslo Accords 30 years ago, the promise of a Palestinian state, this refusal and clearly this resistance to it, encounters a serious obstacle. Is that if we take the borders of this greater Israel that they dream of, from the river to the sea, you have a majority of Palestinian Arabs in that territory. It becomes impossible, unless it's, a pure apartheid state. And we saw what happens to apartheid states. They're inherently unstable, and ultimately they collapse, and that will happen. There's no future for Israel as an apartheid state, because there's a majority of Palestinian Arabs there, and some of them are indifferent to the fate of the Palestinians. Some of them, no doubt, would be happy if they left. But we had that in Nazi Germany too. We had Nazis who would have been happy for the Jews to leave Europe. Just leave, go somewhere else, go to Africa, go to the Middle East, go to Madagascar. There were different plans for them. Go to North America, but leave. And then there were others, and they were in control, who said, well, you can't leave, and you're not going to leave, but you are going to disappear. And I'm increasingly convinced that this is the prevailing view of those who are in charge in the state of Israel.
Mm-hmm. If you allow me to go back to our previous point on complicity and the potential of criminal liability for third states, if there is a conclusion by any court that genocide is happening, do you think there is a strong legal case to make based on the 2007 judgment at the ICJ, but also perhaps other precedents that US officials, in addition to British officials, German officials, of complicity? So far, the two cases of genocide are before the International Court of Justice, which does not really hear cases against individuals. It deals with state responsibility. The ICC has not really used the genocide accusation yet in its ongoing investigation. So do you think there is a strong legal argument to make that, first of all, US officials, whether the former president or the current president, Trump, in addition to British officials and Western officials in general, of complicity in what's going on, or even aiding and abetting by contributing to the provision of arms to Israel?
There's very certainly a good case to be made. Bear in mind that we're talking about the genocide issue at two levels. One is the responsibility of states for committing genocide, and the other is the responsibility of individuals who would be individually committed of the crime. With regard to the states, one of the obstacles we have is getting jurisdiction at the International Court of Justice, finding a court to rule against the state. And this is not always straightforward. The United States is fairly well insulated against the International Court of Justice. So it's not a simple thing to get the United States into the International Court of Justice. With Germany, it's a different case, and Nicaragua has taken the lead in suing Germany at the International Court of Justice for failure to prevent genocide and for complicity in genocide. We'll see how that case evolves and the evidence that they have. And it will, to some extent, depend also on the South African case, probably. I'm sure that when Nicaragua filed the case, I think Nicaragua even indicated that they were thinking of suing other countries too. And there are certainly some good candidates that they could go after, wealthy countries in the West who've been very supportive of Israel. That's the first thing. The second are the individuals. So individuals who are in a state who play some role in the, but they do have to be individually responsible. It won't be enough to just say that he's a Canadian politician, he voted for this, therefore he's an accomplice in what's happening in Israel. There'll have to be something far more serious, and there'll have to be a desire at the International Criminal Court to take that on. So far, the International Criminal Court, although they have decided, the prosecutors decided to pursue 2 Israeli leaders for crimes against humanity and war crimes, but not for genocide. That could change. It could change also at the initiative of the judges. And in one of their rulings, the judges hinted that already they do have a case for genocide. It's premature for them to do it, but certainly if the case advances, and as it advances, the 3 judges of the pretrial chamber or the judges at the trial, if one of these cases goes to trial, could say, we have enough evidence for genocide as well. We're going to add that to the charges. So really the problem at the International Criminal Court is that this is a court that has actually quite limited resources. That, it's a court that's been in existence now for more than 20 years, and they have had 5 or 6 successful prosecutions. They've only had, a dozen trials. And there's a limit to whether they can take on all of the ministers of defense in all the NATO countries and charge them with complicity in genocide. But theoretically, it's possible. It's also possible because the jurisdiction of the International Criminal Court is based on the fact that the crimes were committed in Palestine. It's on the territory of Palestine. And this is important. The court, as a general principle, has jurisdiction over crimes committed on the territory of a state that joined the court. Could assistance to Israel committing genocide, or for that matter, crimes against humanity and war crimes, from Washington be punishable by the International Criminal Court? To me, it's possible in theory. It's not really been done yet at the International Criminal Court to prosecute a country or the leaders of a country for the effects that they have on another territory. But if the United States has contributed to genocidal acts or war crimes in Gaza, which is the territory of the state of Palestine, then in principle, American leaders could be prosecuted today at the ICC.
Charles Taylor, for example, the former president of Liberia, he was convicted based on the accusation of aiding and abetting crimes in another country, in this case Sierra Leone.
Yes.
And he's now serving his prison sentence in the United Kingdom. So there is precedent in the case law, but perhaps for the US this could be unprecedented.
Well, it would be unprecedented, and it would severely anger the United States. But listen, they're already angry. They're already they have turned on the court and adopted various measures to try and attack the court. It's kind of pathetic, really. They don't, the measures they've taken. I mean, the prosecutor, Karim Khan, can't go to the United States. And if he has assets in the United States, they could seize them. I don't believe they've done it.
Professor, what was your initial reaction when you heard that President Trump issued his executive order to sanction members of the International Criminal Courts?
Well, of course, I wasn't surprised that he was doing this. He had done this before, 4 years ago. And it was entirely predictable that the United States would do this. They have tried at various stages to attack the court. They have yet to find the Achilles heel of the court. They haven't yet found anything that really damages the court or the individuals around the court. I know there was a bit of a panic. They say that the court decided to pay the salaries of all the employees 3 months in advance because they were afraid that the US domination of the banking system would make it impossible for them to pay the salaries. But, the court is based outside of the United States. It's based in Europe. And so far, they have not come up with anything brilliant. The first time they attacked the court was back in 2002 under the first George Bush administration. And it had no impact. I mean, in my opinion, it had no significance. And eventually they dropped it, and they discovered that some of the measures they had taken caused more harm to their interests than achieving what they wanted. So far, I think their efforts are quite pathetic. I feel sorry for poor old Karim that he cannot take his holidays in Disney World this year. And I also, if he still has an American bank account and he hasn't closed it, then I feel sorry for him by leaving himself exposed that way. But he's had lots of time to withdraw his money from the United States, if he has any there. This is nothing. How could this stop a global institution like the International Criminal Court? You know, the Americans can inflict pain on people, but there are limits to what they can accomplish. And if they really want to do it, they need the cooperation of their allies in Europe, especially when banking measures and so on are involved. And they're not going to get that against the ICC. This is where there's a profound difference between the United States and the Europeans, because the Europeans are committed to the International Criminal Court as they are to the International Court of Justice. And so they're in a different place than the United States, who, you know, are, the United States is the Wild West. We know that. We've always known that. But this is where there's a real split with Europe.
And Professor, what's your reaction to the latest decision by Hungary to withdraw from the Rome Statute? It's the first EU country to leave the treaty that established the International Criminal Court, and it was one of the first that joined the treaty. So what's your reading of that?
Well, this has been predictable as well. Even when in November, when the arrest warrant was issued against Netanyahu, Orban in Hungary said, I'm going to invite him to come to Hungary. And it's unfortunate that Hungary's taken this step. I hope it'll be the last EU state to withdraw. There have been threats before of mass withdrawals from the court, but they have not materialized. 2 other states have withdrawn, Burundi and Philippines. But other states threatened to withdraw, and then they retreated from that position. We don't have any move elsewhere in Europe of states threatening to withdraw. A lot of it might have been avoided, this problem, if the court had adopted a little more cautious approach to the issue of immunity of heads of state and government, because it really is, you know, there's no argument. Let me put it another way. There's an international law argument that's not, that has some substance to it, that someone like Netanyahu benefits from a form of immunity before a court like the ICC. This is based on a judgment of the International Court of Justice. We have a difference of, I think we cannot reconcile the position of the International Court of Justice and the International Criminal Court. Can't entirely reconcile them. So I think there's some evidence that Hungary is not the only state that doesn't really go along with that decision of the International Criminal Court, the appeals chamber of the International Criminal Court of 2019, saying nobody has any immunity before the International Criminal Court. And that was a bold step into the unknown, and maybe the court is going to pay a little price for this.
But isn't this stipulated in the Rome Statute?
No, not really. It's a debate about what's in the Rome Statute. It's true that the Rome Statute says there's no immunity in the Rome Statute. It says that explicitly in the Rome Statute, because that's the agreement of the countries that joined the Rome Statute. But Israel didn't join the Rome Statute. So Israel never agreed to that. Hungary did. So Orban, he can be prosecuted by the ICC. But Israel didn't. It's the same problem with Putin. And, you know, some of the European states, France, for example, when Putin was charged, instead of rejoicing, instead of saying, yes, great, the ICC is finally delivering France just said, we take note of the fact that Putin has been charged. And my suspicion is that France also is not in agreement with the ICC's position. That doesn't mean that they will invite Netanyahu to come to France, and it doesn't mean Netanyahu would go either. You see, if Netanyahu were to go to France, Macron doesn't decide who gets arrested in France. They have an independent justice system. Macron can't control that. So even if Orban says to Netanyahu, you can come to Hungary, don't worry, Orban has sufficiently damaged the courts in Hungary that even Netanyahu trusts him when he says, don't worry, the courts in Hungary are not going to cause a problem for you. But Macron won't do that. Starmer in the UK, he won't do that. If someone says to Starmer, what will happen if Netanyahu was to visit the United Kingdom, he'll say, well, I don't know what would happen because the courts decide that. Starmer knows that. And the courts in the UK are independent. And Netanyahu will know that too. That's why he won't come to the United Kingdom. That's why he won't go to France. I don't know that it's devastating. It's unfortunate to see this happen with Netanyahu. Let's see how many other places he wants to travel to.
But why does it matter that Israel is not a signatory to the Rome Statute in this incident? You know, the jurisdiction is not based on Israel's membership of the Rome Statute. It's based on the court's jurisdiction on the situation in Palestine. So theoretically, it does have jurisdiction on nationals of non-members of the ICC.
Well, this is the argument. I'm just saying that this is legally, it's an argument where there are two credible positions. And it's been resolved in different ways by the International Court of Justice and by the International Criminal Court.
Could you unpack that, please? Because not all our viewers are familiar with the ICJ case of 2002.
2002.
Yeah.
Basically, the principle is as follows. That states have, the head of state of a state is immune from prosecution by the courts of another state. So I don't think this is really going to be disputed by many countries, if any, that it's not possible, for example, for Ukraine to judge Putin. And it's not possible for the courts of Palestine to judge Netanyahu because of the immunity of a head of state vis-a-vis the courts of a state that of another state. It's different for certain international criminal tribunals, according to the International Court of Justice. And the two examples where we've seen this issue is at the Yugoslavia and Rwanda tribunals, especially the Yugoslavia tribunal and the Special Court for Sierra Leone, also a court created essentially by the United Nations and by the United Nations Security Council. So there the idea is that since it's the UN, this is the whole world coming together. And so it's not the same issue as one state judging another. The problem with the ICC is that it's in between those two. It's a club of 125 states. And they've agreed in their statute that there's no immunity. But the immunity of the head of state, in general, is created by international law broadly, what we call customary international law. And so this means, and this is why it's in the Rome Statute, the people in that club, the 125 members of the Rome Statute, have agreed that there's no immunity for members of the club. But they can't take away the immunity of those who are not members of the club. That's the argument. So the countries that haven't joined the ICC, starting with United States, Russia, China, Israel, Indonesia, India, Pakistan, and many of the Arab states, most of the Arab states, other than Palestine and Jordan, they can say, our head of state, you can't take that away from us in your club, because all you're doing with the 125 states is doing collectively what you can do individually, which is repudiate their own. So this is the argument.
But also, in the case of Sudan, for example, Bashir was not the head of state, that was a member of the Rome Statute.
That's
but
right.
There was no backlash at the time.
There was backlash. There was backlash, and many states, including members of the court, refused to arrest Bashir. The argument in the case,
there was no backlash by the same states that are now supporting the immunity of Prime Minister Netanyahu.
Well, it depends on where Bashir went, you see, that's all. And he went to states that were friendly to him. They're not the same states that Netanyahu would go to for obvious reasons. So he went to China, but China was not a state party. But he went to Jordan, for example, Bashir. He went to South Africa. And there the government said, no, we don't want to arrest him. And that led to this bold decision by the judges of the appeals chamber in 2019 who said, there's no immunity and it doesn't matter whether your state joined the court or not. I'm not arguing for one position or the other. I'm being an academic lawyer and saying there are arguments here.
There was also a more recent argument in the Putin case, right? In Mongolia, when he visited Mongolia.
So Putin did the same thing on Mongolia. What's troubling is that these are states that are members of the court. Mongolia is a member of the court. Hungary is a member of the court. And it's troubling to see them do this because they should also be respecting the judgments of the court. Even if they don't agree with them, they should be respecting the judgments of the court. But this is the dilemma that we're in, and this is what the argument is. And it is clear that this is a court that's a club, and the members of the club, when they lose confidence or when they dispute the judgments of the court, then they're enthused, they can quit the club. And that has happened in a few cases. Of course, my suspicion is that there are other members of the club as well, others of the 125, France would be an example, who are not really comfortable with the idea that the immunity is taken away, not just from members of the club who've joined the court, but from other states. They're not really comfortable with that. And that's why they didn't show any great enthusiasm when Putin was charged, although they don't like Putin, obviously. They detest Putin and should have been rejoicing when he was charged. But they didn't. And they didn't rejoice. They just acknowledged that this was happening. So I think these are things that are difficult to entirely appreciate because they're decided by countries within their own foreign ministries. It's secret. We don't know what their view is exactly. And we don't know what the debates they're having. We only see the little reflections of it. Like, as I say, when France says, well, we take note of the arrest warrant against Putin, which is inconsistent with France's enthusiasm for going after Putin. That's all. So this is the problem the court is confronting. The problem will disappear when the ICC becomes the world court with 195 members. But it's not there yet.
You were present in the Rome conference.
Yes, I was.
Where the statute was being negotiated. What did you hear at that time when they were discussing Article 27 and Article 98, like the articles related to immunity? Did this issue come up during the Rome conference?
Not this issue. Something related to it came up, which is not the immunity of the head of state, but the immunity of diplomats. Because states said, well, we can't arrest foreign diplomats. What if the ICC asks us to arrest Ambassador so-and-so of another country? And so we do have a provision in the Rome Statute that talks about how that is supposed to be addressed. And it doesn't give a clear answer to it, but it acknowledges the problem. And the judges of the appeals chamber in 2019 basically just disregarded this part of it. There are some other facets of this that are interesting as well. The provision in the Rome Statute, Article 27, has 2 paragraphs. So it has a paragraph that says you cannot invoke as a defense your official capacity. And this is a text that is basically borrowed from the Nuremberg trial And from the Yugoslavian and Rwanda tribunals, basically it's the same thing. It says you cannot, as an individual, invoke in defense the fact that you were actually kind of an instrument of a government rather than an individual with your own criminal intent. That's paragraph 1 of Article 27. Paragraph 2 is about immunity, and it says there's no immunity for a head of state or government. So why are there 2 paragraphs? Well, they do 2 different things. The first paragraph provides a defense to an individual who goes to trial, and at the trial, the prosecution presents their evidence, we hear the case, and then the judge turns to the defense lawyer and says, so what do you have to say? And that's when the defense lawyer can say, my client was the prime minister, and he just had to do what the state wanted to do. He didn't control it. And the judge will say, well, no, that's a worthless argument because paragraph 1 of Article 27 says that you can't invoke that argument. The paragraph 2, the immunity issue, is something that gets invoked at a different time in the trial. It's not a defense. It's an argument that gets invoked at the beginning of the trial before there's any evidence, and where the lawyers for the government concerned come and say, you're prosecuting our head of state, and you can't do it because he has immunity. It arises at a different point in the trial. And by the way, the immunity is something that a government can waive. It can renounce to the immunity. Governments do it all the time. So here in London, you have a diplomat who does something horrible, does something reckless, irresponsible, commits a crime, and goes to jail. And the lawyers for the government come to court, and the judge says, well, you're charged with this crime. And the diplomat says, but I have diplomatic immunity. And the lawyers for the government say, not the British government, for the government of the person charged, of the diplomat, say, that's okay. We don't care. You can keep him. Try him and throw him in jail if he's guilty. Governments do that often because the immunity belongs to the government. The defense of official capacity belongs to the individual. So this is the nuance. It was never discussed,
But
to
what's
be
your
quite
view?
frank.
Where do you stand on this? Like, does Prime Minister Netanyahu now, as a serving Prime Minister, does he enjoy immunity before the International Criminal Court? Do other states that are members of the Rome Statute have the legal obligation to arrest and surrender him to the court?
Yes, they do. Because this is, and I'm presenting you, you've asked me, I'm presenting you the arguments on both sides. I'm saying that it's debatable, and that it's not unreasonable to think that the judges of the ICC, of the International Criminal Court, could also have accepted the arguments that I set out and say, listen, this is going too far to prosecute the head of state of a country that hasn't joined the court. But they didn't do it. They took a decision, and before the International Criminal Court, that's the law. So Netanyahu can raise the argument, but in principle, the judges, the first time it would happen would be if he was brought before the 3 judges of the pre-trial chamber, and if he were to say, I have immunity, they would say, no, you don't. Read the judgment of the appeals chamber of 2019. And I say the same thing to France and Hungary and the other countries. They have to respect the judgment of the court, regardless of what you think. I'm an academic. I can, and as a lawyer, I can argue both sides. There are arguments on both sides. But at the ICC, if it were to come before the ICJ, this issue, in some form or another, then it would be difficult to predict the result. But at the ICC, it's entirely predictable, the result, because we have a judgment of the appeals chamber, and Netanyahu is going to be confronted with that. And the judges of the court are going to respect that. And so should the states that are members of the court. They have to do that as well. Hungary is not doing it, and that's a problem. Hungary has gone a step further. They don't have to quit the court to do it.
But do they still have a legal obligation?
Absolutely, they do, because the provision that allows them to quit the court says that it takes effect 1 year after. So today, by failing to arrest him, they're violating the statute of the International Criminal Court. And hopefully there'll be some consequence, some pain will be inflicted upon them for doing this. They're being lawless. The fact that you disagree with judgments of a court, I live in the UK, I might have disagreements with several judgments of the Supreme Court of the United Kingdom. But I can't refuse to respect them. I have to abide by them. And that's the case for the other members of the ICC as well.
And doesn't it also set a precedent for other nations to disregard the decisions of the court?
Absolutely.
Like today, the Belgian Prime Minister declared that that Belgium would not arrest Netanyahu if he visits Belgium.
Well, I haven't seen that statement by the Belgian Prime Minister, but I think the Belgian Prime Minister is rather in the same situation as the Prime Minister of the United Kingdom and the President of France. They don't control the courts. They can't rule that out. They can't, because they don't know what a prosecutor is going to do in Belgium, and they don't know what the courts are going to do. And they would be wise not to suggest that they're in the same position as Orban, who is a tyrant and who has done his best for several years to emasculate the courts of Hungary. So maybe Orban can say confidently, yeah, don't worry. I control the courts. I control the judges. Maybe that's true. But I don't think it's true in Belgium.
Are you concerned that other countries would follow suit and decide to withdraw from the courts? Like, what do you think would be the impact of Hungary leaving the court? Like, are you expecting a domino effect?
No, I'm not expecting a domino effect. Anything is possible. I was actually more concerned about states leaving the court 3 or 4 years ago, because the court has probably underperformed in terms of its ability to deal with a significant number of cases and important cases from important conflicts and so on. And there was a great resistance that was very visible after Karim Khan became the prosecutor in 2021. He said, I don't have enough money. I need more money for my budget to do what you're asking me to do. And states said, you have enough money. We're not giving you any more money. And it looked, they were getting a bit impatient. The British showed impatience. They made statements that were very critical of the court. Then the court got involved in Ukraine, and then the wind changed. And then the states that were members of the court, especially the Europeans, who are the bankrollers, they provide the money of the court. And they were very enthusiastic because the court got very engaged in the investigations into the Russians in Ukraine. They didn't really expect it to investigate Palestine, but they couldn't control it either. And for a few years, the prosecutor was also quite indifferent to the situation in Palestine. So he investigated Ukraine with enthusiasm, and he didn't want to go near Palestine. But that became untenable by 2024. And so he did more serious investigation and has issued these charges. And that's part of the problem about the future of this institution. It's got 125 states. They're not all wealthy European states. The biggest cohort within the court are the African states, who are, as a general proposition, really quite happy to see Israel being investigated about Palestine, or Israelis being investigated about Palestine, and who are more indifferent to the conflict between Ukraine and Russia, which they see as a border war between two wealthy countries, wealthy developed countries, whereas they feel much more sympathy with the Palestinians, who they see as an oppressed people in a colonial type environment because of their history. So the court can't please all of its members all the time. And its challenge will be, can it give enough satisfaction to these different constituencies that none of them get impatient. Around 2011-12, when there was a threatened withdrawal by several African states, it looked like the court had tilted too far against Africa and was not actually investigating stuff outside of Africa. And the Africans didn't like it, and they showed it. And a few of them threatened to withdraw. The African Union threatened a mass withdrawal, but it didn't happen. We might get that in Europe as well, but at the same time, the Europeans have invested huge amounts of money, including huge amounts recently in the Ukraine investigation. I don't see them turning their back on the court immediately. For sure, they didn't want the court to go after Israel, which it's doing. But that's what you have when you have an independent court. You have to accept that they may go after your enemies, the people you don't like, but sometimes they may go after your friends, and you just have to suck it up and live with it.
Mm-hmm. And Professor, to conclude, I don't want to take more of your time today. How do you see the future of international criminal justice right now? What's your prediction? Are you hopeful? Are we at a good place right now compared to the first days when the Rome Statute was still being negotiated? Given the purposes of the Rome Statute to fight impunity, to hold people at the most senior levels of government accountable. Do you think the institution has succeeded so far to achieve its objective? And what do you hope?
I've done a lot of writing and research about the history of international criminal justice, and I'm better at understanding the past than I am at predicting the future, I'm afraid. The American writer Mark Twain made this famous comment that nothing was harder to predict than the future. But he also said, I think, he said, history doesn't repeat itself. I think it was Karl Marx who said history repeats itself. But he said, it may not repeat itself, but it rhymes. So this is the thing. How do we know what the future is? We know the future by looking at the past and wondering if it's going to be like that. Well, international criminal law, international criminal justice started, as we know it, it started around 1919 at the end of the First World War. And there was a wave of activity that lasted only a year or two. But it was clearly the birth of this idea of holding individuals, including leaders of countries, responsible for violations of crimes of interest to the international community. Not ordinary crimes like drug trafficking and murders and so on, but crimes against humanity, war crimes committed in an international conflict and so on. And then it all went dormant for about 20 years. And then it revived during the Second World War. And there we had the first trials, the Nuremberg trial, the Tokyo trial, the Genocide Convention was adopted. There was a whole blossoming of activity. And then it all died out again in the early 1950s. And although there were attempts to revive it during the 60s and 70s, you couldn't get enough traction globally for that to happen. And it was only in the 1990s that it revived. For many years after the 1990s, I used to think, when does this wave end? When does it all cool down and stop again for another, like it has done twice in the past? That hasn't really happened. But we have gone through different phases. We had this phase in the first decade of the 21st century, where we had the temporary tribunals for Yugoslavia, Rwanda, Sierra Leone, which were very successful. They had their work was defined for them, and they did a pretty good job of dealing with the cases of the leaders of those conflicts. Pretty good within reason, and they were shut down at a certain point. But you could say They did the job they were supposed to. The ICC has struggled to find its way, and I think it's still struggling to find its way. As we speak right now, in early 2025, the courtrooms at the ICC, they have 3 of them, they're all empty. They don't have any trials going on. And there's one trial that's been stalled, so they're waiting. The defense lawyers say they need more time to bring a few more witnesses. But basically, they have nothing planned. And the only thing in the future now, they took in the former president of the Philippines, brought him into custody. He's in detention. But his trial is not going to start for another couple of years. So we're going to have, I'd say, another year, a year and a half of empty courtrooms at the ICC, and the countries that are spending millions and millions of euro on that institution are going to be scratching their heads saying, what are we paying for? Their taxpayers are going to say, why are we paying for these empty courtrooms? You know, they have a staff of 1,000 people and they're supposed to be doing trials. So that may be bad management at the court, but it's all part of an institution that still seems to be struggling to find its way. Will that get sorted out? Will that get resolved? Hopefully, yes. If it doesn't, at some point, states will get impatient and they may say, listen, you're like the League of Nations. We had to start again with the United Nations. We had to learn our lessons and try make a second try. We'll rewrite the Rome Statute and learn some lessons and make something different, maybe. And meanwhile, there is certainly a heightened sense of the importance of international criminality everywhere in the world. You have a conflict breakout and people use the language of international criminal law. They talk about war crimes, crimes against humanity, genocide. They ask for prosecution. They talk about setting up special courts. They talk about other types of measures of what we call transitional justice. That's all now a big part of our landscape, the broad landscape of international law and of human rights. And I don't see that changing much in the next 5 or 10 years, but beyond that, it's difficult to say.
Professor Schabas, thank you so much for your time today. I appreciate it. I know you're very busy, so thank you.
My pleasure.
It's a pleasure. Thank you.